Testing. Okay. But it should work.
Testing. Perfect. All right. Good afternoon, everybody. Thank you all for being here. My name is Russell Huddleston. I'm with Region 9 EPA, and I'm in the Wetlands and Oceans section. I'm the 401 lead, and hopefully this will work. I'm actually co-presenting with some of my colleagues who are going to be doing this remotely. But first, I just want to thank you all for being here and for letting me be here. I want to acknowledge that I live and work in the San Francisco Bay Area on the ancestral homelands of the Ramaytush Ohlone people. Today we're going to be talking a little bit about some of the current rule updates to the Clean Water Act and a couple proposed rules that we're still working on. So we'll begin, hopefully if we can get, I don't know if Joe, if you can hear me, if you're able to log on. I'm going to have Joe Morgan, who's also in the Wetlands and Oceans section with me in Region 9, talk about the updates to the conforming rule to the waters of the U.S. definition in light of the Sackett Supreme Court decision. So we'll see if we can get Joe online here. Bear with us for a moment on the, please, thanks for your patience. Well, maybe while they're figuring that out, we could move on. Any luck? Well, we'll move on to, well, we're trying to get Joe online here. We'll talk a little bit about the final updates to the Clean Water Act 401, Section 401, which is the water quality certification improvement rule. So the 401 part of the Clean Water Act is a really important mechanism that allows for states and tribes to really protect their water quality from any federal action, any federal license or permit that results in a point source discharge into waters of the United States. And so what 401 says is that a federal licensing or permit agency cannot issue that license or permit until they receive water quality certification from the state or tribe where that discharge will occur. And so the certifying authority can either issue a certification, or they can deny the certification, or they can expressly waive the certification. But one of those actions has to occur before that license or permit can be granted. So it's a pretty important tool for allowing states and tribes to protect their water quality from federal permitted actions that result in discharges. So this new rule, it's only the second time since the water quality rule came out in 1971 that we've addressed through rulemaking the 401 certification process. The goal of this new rule is really to provide a more consistent, stable, predictable, transparent rule, and also really get back to the key principles of cooperative federalism, really giving more authority back to states and tribes in the certification process, and to really make sure that we're doing what's intended of Section 401 to protect water quality. So just real briefly how the certification program works. So the project proponent, or the person applying for the federal license or permit, The first thing they do is they contact the certifying authority and they ask for a pre-filing meeting. This is an opportunity to, hey, we've got this project coming up. We're going to be requesting a water quality certification. It provides an opportunity for some initial consultation. After that pre-filing meeting, then they request a request for certification from that authority. And at that time, once that request is made, the certifying authority under the new rule will work jointly with the federal agency to determine what's known as the reasonable period of time. And that's the time period in which the certifying authority has to make a decision and to act on that water quality certification. And once they make that decision, then it goes to the federal licensing or permitting authority. But it's not quite done there. There's another process. It's an important process, which we'll talk about more in the talk here, but it's known as the neighboring jurisdiction determination. And what that does is that's intended to protect any downstream waters that could be impacted by that certification and that permit decision. And so that neighboring jurisdiction is an important sort of post-certification process, and that process also has to be completed before the federal or license permit can be finally issued. So I want to talk about a couple of the key changes that are in the 2020 rule, key changes from the 2020 rule that are in the new improved rule. One thing is that it really provides more flexibility for the certifying authority in that pre-filing meeting. Under the 2020 rule, there was a mandatory 30-day waiting period. So the applicant would request a pre-filing meeting and then they had to wait 30 days before they could act on submitting a request for certification. The new rule still has that pre-filing meeting component, but it allows the certifying authorities to waive or shorten that period as they see fit on a case-by-case basis or on a programmatic basis. So it's really up to the certifying authorities whether they want to have a pre-filing meeting or how long of a period you want to be between that, if full 30 days, or if you want 10 days or whatever. It just allows much more flexibility and more options for the certifying authority. Another thing that's important about the new rule is it really allows certifying authorities the ability to define more explicitly what they would like to see in terms of a certification request. The 2020 rule had very specific things and it was limited to those specific things. The new rule goes back to kind of the way it was before, and it really allows the certifying authority to, as long as it's transparent and it was published and the applicant is aware of what the requirements are, that those requirements are up to the certifying authority. So it puts much more of that, gives the certifying authority much more ability to determine what they would like to see in that certification request. The other thing that's really different, and this is the first time that the Section 401 has done this, and that is that the reasonable period of time, so the period of time that the certifying authority has to make a decision and act on that water quality certification, that's known as the reasonable period of time. And previously, that has always been determined by the federal licensing or permitting agency. They have told the certifying authority, you have 60 days to act on this decision, or 90 days or whatever. The statutory requirement is that it has to be within 1 year, so it can't be longer than a year. But the new rule provides for a joint agreement between the certifying authority. So if the tribe is the certifying authority, they work with the federal licensing or permitting agency to determine that jointly that reasonable period of time. And if they can't come to some agreement on that, the default is 6 months. So it's sort of that halfway point between the full year and 60 days. So that 6 months is sort of the default, but the intent is really to have the federal agencies and the certifying authorities work together to come up with a reasonable period of time for that certification action. The other thing that's really important about the new improvement rule is it goes back to sort of the way the earlier 1971 policies were, and that is once 401 is triggered. So 401 is triggered by the discharge that's licensed or permitted by a federal agency into the waters of the U.S. Once 401 is triggered, the certifying authority can then look at the impacts of that activity on water quality for the tribal waters or the state waters. So it expands it from looking just at the discharge So it can look at things like, is the project going to result in soil erosion? What are they doing to address stormwater? Other aspects that might affect water quality can be analyzed by the certifying authority as part of that assessment of the project. So it's not limited as the 2020 rule to just the discharge itself. It can actually beyond looking at the total realm of water quality impacts that might result from that activity. And finally, it also allows for modifications, which the 2020 rule did away with that, but the current rule brings that back as long as those modifications, as long as those changes are mutually agreed upon between the certifying authority and the federal agency. And I think one of the really critical things, I think, for the tribes is the new rule really provides more options for tribes to take part in the 401 certification process as through the treatment as a state program. And we'll talk a little bit about that more later on in the slides. I don't know, are we able to get Sunny yet?
Dan, how to? No, not yet.
Okay, we're still working on it. Sunny was going to talk a little bit about the 401A2, the 402 process, which is the National Pollution Discharge Elimination System, which also sort of interacts with 401. So hopefully we'll be able to get Sunny on here. But I want to talk a little bit about the neighboring jurisdiction process, because this is kind of the second component of how the 401 certification program works. So the first part of it is that certifying authority is making a decision whether to certify with conditions, to deny the certification, or to waive the certification. Once that decision is made, then the federal agency notifies the EPA, and we look at that permit action and the certification decision, and we have to make a determination whether or not there's a potential for that activity to affect the downstream waters of a neighboring jurisdiction, whether that be an adjacent state or a neighboring tribe. And if EPA then does what's called a may affect determination, that's all we have to do. We just have to say this, we think there's a potential that this activity may affect a downstream tribe. And then it's up to the neighboring jurisdiction to actually look at the project and look at what is in the permit requirements, what's in the certification requirements, and determine whether or not they think as a neighboring jurisdiction that activity will affect their downstream water quality. If the determination by that neighboring jurisdiction is a will affect, then there's a whole separate process that gets kicked in that could potentially involve a public hearing, coordination with the certifying agency, with the federal licensing agency to determine what needs to be done in order for the project or the activity or the permit conditions to address those water quality concerns. And again, that process has to be satisfied before the federal licensing or permit can issue that. So the Clean Water Act is really not just protecting the area where that point source discharge is occurring, but it's also intended to protect those downstream neighboring jurisdictions. So what's really different about this new rule, and I think what's really important, and we'll be talking about this more in a session on Thursday, specifically addressing treatment as a state, but what the new rule does is under the current system, tribes that do 401 water quality certification are often, it's tied directly to tribes that have the water quality, EPA water quality approved standards under Section 303C of the Clean Water Act. What the proposed rule does, it sort of splits those apart and says, if tribes don't want to go through that whole process of developing their own water quality standards under 303C and just want to take on the role as a certifying authority and issue water quality certifications, you can do that without having to go through the 303C process. So it creates sort of that opportunity for tribes to take on the certification authority, just that part of the Clean Water Act. And then it also provides a provision for tribes that maybe don't want to take on the whole part of doing the certification, but want to be considered as a neighboring jurisdiction, because neighboring jurisdiction, under the way the Clean Water Act is written, there has to be some kind of a official jurisdiction there, whether it's a clean water, the full 303 water quality standards and 401 certification, Or under the new rule, you can just say, we just want to have treatment as a state for 401A2 for the neighboring jurisdiction process, in which case you don't have to issue the certifications, you don't have to have the water quality standards. But if EPA says, hey, we're worried about this, there's a big project, this has potential water quality impacts, we want to let the neighboring jurisdiction know. If you have tasks for 401A2, then you are involved in that process and you have the ability to have input on that project and activity as a neighboring jurisdiction. So that's kind of a really important change in this rule. It really provides, I think, a lot more opportunities and a lot more ways for tribes to be involved without having to take on the whole onus of the water quality standards and certification if you choose not to. So there are lots of available resources on the 401 rule on our website, on the EPA website. There's good fact sheets. There's a good table that compares, it's the Appendix A, that goes through the 1971 regulations, the 2020 rule, and then the changes that are in the final 2023 water quality rule. And this rule will go into effect. It was published in September. It will go into effect November 27th of this year. Once this new rule goes into effect, all of these things, all of these changes apply. The one thing, any certification that happens prior to that date, it's not retroactive, so we can't go back and change certifications that are issued prior to that, but on the 27th and after that date will be under the new rule. So again, there's more information here on our EPA website, and so we can go there. Any luck with getting any of our remote speakers yet? We can hear you, Joe. That would be great, Joe. Thank you.
Yes, we can see him.
Okay, Joe, I think we're good. Just since we've got Joe here, does anybody have any questions on that? Just, well, we've got Joe. Yeah, let's bring you the mic here.
Hi, I'm Brie Hernandez with the Bishop Paiute Tribe. I have a question about the connecting waters from a navigable source to a wetland. Does that have to be navigable as well, or can it be like? I ask because we have a 25-acre wetland that's adjacent to a creek, which it's kind of confusing. But the way that we get water fed through there is through a ditch, like a irrigation ditch that goes through there. So just kind of wondering if that's considered connected or not.
Hi, this is Eddie from Pachanga. I had a quick comment and observation about the new definition is that going with, again, the permanent connection is very limiting for the Southwest, especially here in the arid Southwest. I mean, we just had a very good example this last summer with the hurricane that just came through, and the Coachella Valley was inundated. There was loss of impacts to tribal lands because of the poor management of the flood control districts and the adjacent cities that basically don't take into account that, yes, these water bodies don't flow, but they're significant sources of water when they do have water. And so they channelize these areas into very confined spaces. And then when water flows, there's nowhere to go. And it affects a lot of tribal lands because a lot of times they kind of see reservations as open space and don't think about the impacts to those lands. And so a lot of times tribal lands bear the burden of the poor practice and the poor planning of counties and cities. And because these new rules are limiting the amount of input that we can have with our neighboring counties and cities. It makes it harder for us to really have that dialogue if we don't have a nexus anymore to really have a conversation about their upcoming flood plans or different projects, or if they're doing development, or if they're allowing for more impoundments. When we lose those options to really get conversations going, not just for the environmental portion, but a lot of times with cultural resources, because they are no longer considered waters of the U.S. It's a detriment both culturally and environmentally to these sensitive areas that have been protected by the tribes traditionally, and are no longer under the tribes' control, unfortunately. So I think it's really interesting that even though the Army Corps has its own special appendix for the arid Southwest, that is completely being ignored in these regulations.
This is Sarah Schaefer with Quartz Valley. It's not just a Southwest issue, it's these new, I don't know, I'm super disappointed in the Sackett decision and the effects that it's going to have on Indian country. And in our area, traditional spawning streams would not even be considered waters of the US under these new rules. And some of them are actively being dewatered through legal diversions. So, you know, how's that going to affect their permanence, you know, as being considered waters of the US? I don't know. I guess it's just a comment. It's just super disappointing. These are legal diversions that I'm talking about in over-adjudicated basins, which we have a lot of over-adjudicated basins. So legal diversions completely dewatering streams that are some of the most productive coho streams, which are, you know, an endangered species. And I don't know if these streams would pass the definition of WOTUS now.
Hello, just a really quick question. Is it clarified in the new revision how you guys are going to determine, is it a case-by-case basis for each water system? Are the tribes going to have to reach out to you guys to get that protection? Is there any plan in place by the EPA to respond to this decision? Thank you. Thank you. And then just a follow-up question on that. Is there any specifications for like time, like how much time that would take tribes to acquire based off of the sections that you mentioned? And then that's my last question. Thank you.
She said yes.
Yes.
Hello, I have a question. So if the EPA is basically losing the federal jurisdiction over certain waters, who then ends up with jurisdiction over those more impermanent waters?
Well, thanks, Joe. Just the minute we have left, I just want to mention there's two other proposed rules that are out right now that were published in the Federal Register. The first one has to do with the EPA establishing baseline water quality standards for tribes that have not already established tribal baseline standards. And these are basically water quality standards that are designed to protect human health and the environment, such as setting toxicity limits on fish consumption, ensuring clean water for cultural purposes, and other things like that. So that has been published in the Federal Register. It's a rule that's currently being worked on. It would basically provide a stopgap for those tribes that don't have established water quality standards for us to use when we implement the 401 program, the 402 program, the 404 program, other programs that really depend on those water quality standards. The second proposed rule has to do with tribal treaty rights, and it just basically clarifies to states and water quality certification programs that they have to take into account tribal treaty rights, including fishing rights, traditional use of plants that could be affected by water quality when they're establishing water quality standards. And so those are two proposed rules that directly relate to tribes. There's more information on the EPA website about both those proposed rules as well. Again, they're just in the proposal stage at this point, haven't been finalized, but they have gone through consultation and public comment, and more information is available on the EPA website about those rules. So yeah, I think looks like we're out of time. Thank you all very much. And thank you, Joe. Sorry, Sonny. I think there's another session on section 402. So if you want more information about that, check the agenda.